issues, the law,
Yes.
Okay.
Petition is dated 29th September 2017.
2017.
We rely on the affidavit filed on the same date. We also rely on written submissions.
You confirm in the file? Eh?
Yes, in the file.
Okay.
They are dated 3rd of October 2017.
Dated
3rd of October 2017.
Yes.
And we have further, rather supplementary affidavit dated 3rd
Of September.
of October. And we have our list of authorities, list and bundles of authorities dated 3rd of October. We wish to fully rely on them. My Lord, the petition before you was triggered by a Gazette notice dated 5th September 2017, which is annexed to our affidavit. Where the first and second respondents sought to rely on the presidential election petition number 5 of 2013. For the purpose of time, I refer to the Raila case number 1, Raila 1, to bar the petitioner from participating in the elections of 26th October 2017.
We call them repeated, no, fresh elections.
Fresh elections, yes. Initially they were projected to take place on 17th, but later pushed to 26th of October. I think that is an issue that the court can take judicial notice of. We have not annexed the new
Yeah, it's okay.
I wish to argue the petition in One, I would like to address the issue of the status and applicability of the Raila case 2013. Second, I want to address the issue of the petitioner's status as an interested party in Raila 2017. Thirdly, I will address the court on the interpretation, the proper interpretation of Article 138.5 vis-a-vis Articles 143 of the Constitution. Thirdly, lastly, I look at the violations that are bound to happen to the petitioner if this petition is not allowed. On the first link, my Lord, I wish to submit that
the first status.
Yes, the status and applicability of Raila 2013 is that we do not have a decision or determination of the Supreme Court capable of guiding the first and second respondents in the manner that they did to deny the petitioner the opportunity to run as a president. My Lord, a cursory look at that decision, and we have annexed it as authority number 1 in our list and bundle of authorities, will show that the paragraph that is sought to be relied on,
Page?
it runs from page 3 to...
No, the relevant paragraph.
I'll address you to that when we come
Okay.
to that point. I just wanted to show the court that we have annexed that. We had no decision made by the Supreme Court. It was merely an opinion. I have sought the definition of an obiter dictum in the Black's Law Dictionary, 9th edition, which defines an obiter dictum as something said in passing, a judicial comment made while delivering a judicial opinion.
Is it this 9th edition?
Yes. It is something said in passing, a judicial comment made while delivering a judicial opinion, but one that is unnecessary to the decision in the case and therefore not presidential. I've also sought to rely on the scholarly works of William M. Lille.
Part of your papers?
Yes, it is. The quotation is captured in our submission.
In the submissions?
Yes.
Page?
6 of our submissions, where the learned scholar says, strictly speaking, an obiter dictum is a remark made or opinion expressed by a judge in his decision upon course, by the way, that is incidentally or collaterally, and not directly upon the question before the court. My reliance is on that part, not being a question before the court. It is illustration, argument, analogy, or suggestion. The paragraph sought to be relied upon, it's 289 of that judgment, paragraph 289. Let me confirm that so that I don't mistake. It's actually 291. It's 291.
The one you are highlighting?
Yes, yes, my lord. That is the paragraph that the first and second respondents seek to rely on to bar the petitioner from running as a president in this election. My lord, that is an obiter dictum of that judgment. And why am I saying this, my lord? When you look at page 8 of our list of authorities, we have the issues that were before the Supreme Court for determination. I have highlighted them. Page 8 of our list and bundles of authorities. There were 4, yes. Page 8 of the entire document, but it's page 6 of the judgment.
Oh, it's in the judgment?
Yes, it's in the judgment. There were only 4 issues, and they were agreed issues. The issue of fresh elections was not part of those issues that the Supreme Court was to address. My lord, the first time that question is brought before the court was through the amicus curiae, the Attorney General, who sought directions in the words used or captured in the proceedings. I'm referring to you, my lord, at page 54 of the main document and page 52 of that judgment. It is important. When you look at paragraph 286 of that judgment, the Attorney General, as amicus curiae, invited the court to give directions on a line of relief declared by the court, depending on the finding on merits. Article 185 of the Constitution stipulates that the court goes ahead to capture that. So it was the Attorney General who sought directions.
Did you seek directions on
Yes. Yes, he did. 138, one paragraph 38. Yes.
143?
No, he did not.
Yes, that's what I understand.
He did not. He did not.
No, there's 143 in what does it say here? It's the paragraph below. After 2, it's actually 287.
Yes.
As the first election, the youth at 143 does not tally with its application at the 132 and 3. Then the students of the court answer to the following question. Does the fresh election anticipate the 143 presidential election, including the nomination process, or does it mean a general election is anticipated under 185 and 7? So what was the answer to this question?
The answer is found in the next page, my lord,
Yes.
which I shall be addressing you on shortly. But to just show that that was merely an obiter, when you look at the judgment at page 55, page 53, the Supreme Court starts determination of the issues at paragraph 295 in a clear subheading, determination of the petitions. I don't know whether, my lord, you're with me. I wanted you to capture that.
I'm there,
Yes, yes.
I read before you.
Yes, thank you. Thank you, my lord. So the issues started to be determined at paragraph 295. A very clear heading. So anything that was said before then was clearly a judicial comment in passing, as a by the way. Did not form part.
So to you, determinations come now when
Yes.
resolving the issue.
Yes. And that is what amounts to the decision of the court. So that decision cannot be said, that comment rather, cannot be said to have any presidential value, especially binding presidential value to a high court. If the worst goes to worse, it's only persuasive. It cannot be a binding precedent to the court. Let me go to the second limb of my argument, my lord. I shall be addressing you on the proper interpretation of that comment, judicial comment, but let me first address the petitioner's status as an interested party.
That's your B now.
Yes.
You said,
Yes,
that's
that's my B, yes.
that petitioner status
As an interested party in the Supreme Court case of Raila 2017. The petitioner herein successfully applied to be joined as an interested party in the Supreme Court case. We have annexed that ruling in our list of authorities. It's appearing at page 575. And this is what the court had to say before admitting him. At the very last paragraph, appearing at page 78, I have highlighted it for your lordship. Yes. Consequently, the application conforms to the principles laid out in the case of trusted society, in that the applicant was a presidential candidate in the 8th of August general elections. This is an identifiable stake in the matter, and he will be directly affected by the outcome of the present presidential election petition. So my point here, my lord, is that he was a party to the proceedings of the 2017 case. The Supreme Court had earlier given importance to an interested party. In the case, petition number 15 of 2015, Francis Karaoke, Morua Teto, and another, I've also highlighted that.
Which page? Oh, yeah, it's on the same page. I've seen it.
No, it's not in that page, my lord. Yes, but there's the actual ruling which we have annexed in our. It's appearing at page 68. Yes, an interested party is one who has a stake in the proceedings, though he or she was not party to the cause ab initio. He or she is one who will be affected by the decision of the court when it is made either way. Such a person feels that his or her interest will not be well articulated unless he himself appears in the proceedings and champions his or her cause. Therefore, the petitioner was not a busybody in the Supreme Court matter. He was a party with a stake and who was to be affected by the outcome. As such, he ought either to benefit from the outcome or suffer detriment from that outcome. My lord, it is worth noting that the petitioner supported the petition in the Supreme Court. He adduced evidence, submitted both oral and written submissions in support of the petition, showing that the election was not conducted according to the principles of the Constitution. Why am I saying this, my lord? It's because when you look at the judgment that is sought to be relied upon by the first and second respondents, that judgment says only the petitioner who had contested the results of the election is eligible to go for a fresh election. So if the petitioner is entitled, then an interested party who had a stake and who was to be affected by the judgment also ought to benefit from that judgment. He cannot be wished away. He was not a busybody in the Supreme Court. But suppose, my lord, just assuming for a moment, which is not our position, suppose that the court actually addressed that issue in the said paragraphs. What did the Supreme Court actually mean? The Supreme Court, my lord, was merely giving hypothetical scenarios at these paragraphs. It cannot be said to have exhausted all the hypothetical scenarios, such as the one we have before you today. Because when you look at paragraph 291, it says, bearing the foregoing scenario, does the fresh, meaning there is a scenario the court has already talked about, which appears at 290, the preceding paragraph. And that paragraph is, suppose, however, that the candidates
or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date, then the provisions of Article 138(1)(b) would become applicable. So to me, that is the scenario that the court was addressing at the moment. It was not addressing all the other scenarios. And I know that when your Lordship retires to write your judgment, when you look at those paragraphs, the court will be able to identify the various scenarios that the court anticipated. And the scenario that we are in was not part of those scenarios. Lastly, while I'm still at that, at paragraph 291, still, the second line, the Supreme Court says, the answer depends on the nature of the petition that invalidated the original election. So before the first and second respondents can apply this judgment, they ought to look at the nature of the petition that invalidated the election before the Supreme Court. It is not a blank check. So the court ought to ask itself, what was the nature of the petition before the Supreme Court? The answer is that the nature of that petition was challenging the results of the election because the principles of the Constitution had not been adhered to, which was not necessarily what the Supreme Court was dealing with then. My Lord, thank you. My Lord, let me go to the third limb of my argument. The nature and effect of fresh elections as envisaged under Articles 8, 5, and under Article 143 of the Constitution. Now we have three scenarios under which the country will go back to fresh elections under the Constitution. The first scenario is contemplated under Article 185 of the Constitution. Here, my Lord, it is where the election has not produced a winner. The results are valid, but because of the threshold put under Article 138(4)(a) and B, none of the participants has attained that threshold. In that event, it's only the first runners-up and the second runners-up who go back to the elections. The law is very clear on that. In fact, my Lord, that is not even a court-triggered process. The first and second respondents can sui moto determine that we do not have a winner in this election and declare fresh elections within 30 days. And I believe the reason why we have 30 days is because it's a pretty simple exercise between elections on 8th of August 2017. Those were declared void. They mean nothing in law. So that now, my Lord, if the results had no legal effect, how do you determine who was number 1 and who was number 2, so that you declare only these 2 should go for the fresh elections? Because we do not have a number 1 and number 2. You cannot even argue that the petitioner had conceded defeat. Defeat to what? There was nothing capable of conceding to. Those results never existed. They mean nothing in law. The only interpretation is that we go back to the period before 8th of August 2017. There is no other way out of this. And because of the nature of
I'm not sure you have a lot. I can see us doing a past 5.
I am actually completing because all right.
Okay. You may come to fight them, they close the offices, you find that not in there. So I'm telling you to make sure that you have 10 things.
True.
I know the rest are lost. So make sure you have more in case they close the offices. But those will move faster now. Yes.
Then how do you declare this to be a runoff if there is no basis for the runoff? Because when you look at Article 138(5), the previous results are the basis for the runoff.
Actually, that is not what you.
Yes.
Because Article 40, Article 3 is very clear. It calls it a fresh election.
Most obliged, my
And
lord.
138 is already different. So I believe we are doing with 140, Article 3.
Yes, my lord.
I've been looking for a definition of fresh elections in the Constitution of Akuna. In the Elections Act, I don't know that you found it, I don't know. So you have now to move from there.
That's why, my lord, I'm guiding you on what invalid means, because the words used in the Constitution is invalid. If the court invalidates the election, then it means we never had any elections at all. And that's our stand. Now, my lords, the issue of nullification of elections is not a new concept in Kenya. It has been with us from the very first day we started voting. Courts in every election cycle have been nullifying elections. But now, they've never nullified an election for the president. So the court might actually want to be guided by what happens in other elections, parliamentary and county elections, if the court nullifies elections. And there lies our answer. We go back to elections, to by-elections, and it's a fresh process. All parties are invited to participate in the election.
By elections, everyone contests.
Yes, everyone contests. Because the rationale of nullification is that...
Now, not to stand what the Supreme Court said here. The Constitution, does it place the state who should contest under 140, 143?
The Constitution has not done that, because I believe the drafters of the Constitution, and my client is one of them, I'm glad, must have thought that it is clear what invalidation of a result means. It is not even an issue.
No, they leave it to us to say what they meant.
Yes.
Even though we're not there.
Yes. But I think if the court was to apply that section judiciously, it would only arrive to one conclusion, that
Yes.
if you invalidate, it means nothing. You have to go back to the period before. And that's why, my lord, we have two articles governing repeat elections, 138 and 140. My lord, I wish to invite you to be guided by the words of Professor Otieno Dek, who is the judge of the Court of Appeal and the director of Judiciary Training Institute.
In your papers?
Yes, yes, it is appearing. It is at page 154. It's on the introduction part, page 154. I don't think I have highlighted, but there's a paragraph, there's a line, there is the second last paragraph, the big one. There's a line starting with the contest in an election. I don't know whether you can identify that, my lord.
Well, after the abstract.
Yes, after the abstract and our introduction, we have a line starting with the contest. There's a quotation of OCE, and then we have the... Yes, 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 my lord. Now, the point I'm trying to make here, my lord, is that in an election petition, it is never about the petitioner and the respondents.